Good afternoon, good morning, good evening, depending on where you are, everyone. Welcome to today's session. We'll be looking at issues relating to financing trade and also looking at some market developments that have happened over the last 6 to 12 months. So I'd say the talk will consist of starting off looking a brief overview of structuring, looking at the risks involved, what you can do about it, what risk mitigants there might be, what security you may be able to take, whether that's actually the right thing to be doing, or whether there are other better options as well. We'll be particularly focusing in terms of the security on goods and receivables. And then when we come to the market developments, it will be in two sections, one relating to different products, different approaches that people are taking to try and deal with the gap in the trade finance market, funding gap, and also some more general points of interest, things that are happening in the market that you may or may not be aware of. So with that, I think we will get started. I should say that to the extent you have any questions, please can you put them into the Q&A button, which you'll find on the screen, and then we will pick those up towards the end. Okay, so we get started. So a bit of a sort of refresher to set the scene. When you're looking at structuring, you might say, well, why do we do it? Well, the answer is because structuring is how the banks can get comfortable with the risks, can give their borrowers better pricing, and just generally get comfortable with the deal. But what do we mean by structuring? Well, we break it down into the three elements you can see on the screen. First of all, you need to be able to identify the risk. And by this, we mean looking at the commercial life cycle of the deal and working out at each stage what risks there may be. You need to look at what I call the who, what, where, and when. Who's involved? What are they doing? What are the flows of the money, both on the way in from the funder and on the way back from the buyer to repay the loan? We're looking at the flow of the goods and what they are doing at each stage in the commercial transaction, and really looking at what can go wrong. You then, having worked that out, and for different structures, different commodities, you'll have a different risk profile. And you need to evaluate those risks. So you need to work out what, for any given risk, how likely is it that that risk will actually occur? And to the extent that it does occur, what is going to be the impact on the transaction? Is it going to have a negligible effect, or is it going to be something fairly serious? You can look at then at who should be bearing the risk that you're talking about. Some parties will be better placed than others to accept risks. And I think what you need to understand is that the risk profile for any given stage in the transaction and for any given transaction will change, will be different, and will change through the life cycle of the transaction. So what might work as a risk mitigant in one section may not work in a later part of the cycle. So once you've worked out what the risks are and you've evaluated them, what can you do about them? So there are four options on the screen. An example of eliminating a risk, if you have perhaps concerns about any funding going in, actually reaching the supplier who's going to provide the raw materials, perhaps, then you can make clear through the utilization mechanics that the funding will go direct to the supplier, or at least the portion that's being funded goes direct to the supplier with evidence that the borrower has provided the balance. That way you can secure the supply and eliminate that risk. You can reduce risks by increased monitoring, by having covenants, or potentially having third parties involved that are tied into the deal, and will provide comfort and potentially will be liable should the risk arise. You can mitigate the risk by maximizing recoveries or minimizing the failures. Perhaps you can get credit enhancement to do that. And then you can allocate risk to other parties. Examples of that would be insurers, credit insurance, and or insurance over goods while in transit. You might have off-taker risk being dealt with by way of LCs being issued or guarantees being issued, so you can get comfortable with the credit risk. But the overriding objective is to get the deal done, which means you have to make sure that the deal is viable, both from the funder's perspective and also from the borrower's perspective. Everybody has to do a bit of compromising. Banks are being paid to take risk, so they should be taking some risks, but it needs to be financially viable for everybody. And I think one of the overriding concerns that needs to be dealt with is to make sure that whatever structure you put in place doesn't upset the commercial flow of the deal. The more you disrupt the usual commercial practice of your counterparty, the more likely something is to go wrong. So having looked at that, just to sort of set out the structures that I'm going to be focusing on as we go forward, I've got 6 up on the top bullet. Pre-export finance, prepayment and tolling, which really sort of fall into a particular category where the goods don't exist at the time of financing, and then pre-post shipment and warehouse where they do. I'm not going to go into the details about how all those structures work from a financing perspective. I'm sure you're all familiar with that. But for the purpose of this talk, the critical bit is to do with the goods and the receivables, and to which structures I'm going to be focusing, which are going to be the pre-post shipment and warehousing. Those are the ones where the goods are of greater importance in terms of taking security, making sure that they are secure. Less so for pre-export, prepayment and tolling. In terms of the risks, the first 3 are very much looking at things like performance risk on the borrower, potentially on a supplier of raw materials, and then obviously the buyer credit risk. Probably also some political risk, given it's going to be in country and being exported. But rarely do you focus on the goods in those structures. Perhaps a little bit on the tolling side, but not so much on pre-export and prepayment. For the second 3, there's much more of a focus on the goods. Logistics are very important. You need to make sure the goods get to where they need to go to. And you obviously still have the buyer credit risk. As we're seeing a lot more of the pre-post shipment warehousing, they're the ones that I'm going to be focusing on going forwards when looking at risks and what can be done about them. So looking at some common risks, payment price risk. Here you've got credit risk on the buyer. What can be done about that? As I said, you can either take some form of guarantee or some form of letter of credit as a means of enhancing the structure. You perhaps could take trade credit insurance on non-payment by the buyer, or even political risk. Also, from a non sort of security credit enhancement perspective, you could also get the benefit of multiple buyers. If you have multiple buyers with a good spread, then you're much less likely to have defaults that affect the overall transaction, especially if you've built a buffer into the value of the loan and the debt service compared to the volumes being sold and the amounts being paid by the off-takers. You do need to make sure that the terms of the financing fit with the terms of the commercial documentation. There's little point having a payment date at the beginning of the month if deliveries are already being paid for at the end of the month. You've not got any cash in when the money's due on the loan. So you need to make sure that the volumes and the amounts and the payment dates match with what you're expecting to receive under the financing. Also, you need to look at things like price fluctuation. That may be contractual, something like oil, where you've got the plus and minus percentage, or it may be market prices going up and down, and you haven't set the price by the time you're making the funding. To deal with those, you could have either fixed pricing in the contract, or you might be able to have some form of security margin test in the facility, which requires your borrower to place more contracts within the security package for the financing. I think when you look at the goods themselves, then storage, transportation and processing are the main areas of concern. We're going to look in storage in a bit more detail later on. For transport, I think it differs from commodity to commodity. You've got perhaps less risk with something like oil because it's in a pipeline when it's being transported, versus agri products or metals, which are likely to be transferred at least partly by land, perhaps in trucks, that sort of thing, where theft is obviously a possibility, accidents could take place, etc. So it's more of an issue for the for the non-oil commodities there. In terms of recoverability, if something does go wrong, then I think there, whatever the commodity is, you have that risk. And then additionally, you've got potentially commingling oil when being transported, in all likelihood through pipelines, something like that, where the oil is going to be commingled with all the other oil going through the pipeline process. So what can you do about that? Well, you can try to take assignments of any of the agreements with these parties, probably easier perhaps with the big oil companies where large cargoes are being put through, as opposed to 50 trucks transporting some form of agri-commodity with a small transporter where they don't have a big balance sheet, so it's not going to be particularly helpful to have rights against them. So again, I think it's looking at case-by-case basis to see whether or not looking at the underlying commercial agreements with these transporters is worth looking at and trying to take an assignment of. In terms of the processing, the risks here, you not only have the same risk of the underlying commercial party performing on the processing side, but also you have to be careful when you're looking at taking security, because the product that goes into the processor is not the same as the product that comes out. And you need to look, in all likelihood, a local law arrangement. You need to look at what the position is under that contract and how, and if at all, you can take security over both the initial product, but also the product at the end. You'd also want to make sure that the processor in question waives any liens that they may have, and also make sure that they are holding the goods in the meantime to your order rather than to the borrower's order. So ideally that would have some form of arrangement where the processor is tied into the contract in the funder's favor. Potential mitigants, this is what we're going to go through next, and we're going to focus on the warehouse operation and collateral management in relation to the goods, and then look at security both in relation to goods and in relation to receivables. So who's involved? As I said, listed out the companies here, the sorts of people. I think generally there's an issue about fees and liens and wanting to make sure that that's covered off. So you'd either want to make sure they're covered by the financing, or you would certainly want to make sure that you are entitled to cover those costs and recoup the money through the security package. What you don't want is any of these companies holding on to the goods and either stopping the commercial process or stopping enforcement when things go wrong. I think that the general rule of thumb is, do these parties actually help in any given transaction, or are they likely to hinder? And again, that comes back to your due diligence on them and the role that they are playing in the transaction. If the warehouse owner, for example, is the borrower, so it's not independent, that's more of an issue, and you need to bring in a third party to try and give you greater protection, whether that's a collateral manager or moving the goods to a different warehouse. You've also got to count banks. That's in the list because whilst you would have thought that they would always be helpful, sometimes you have third-party banks, and we'll come on to that a bit later as well when looking at security, where accounts at third-party banks can cause a bit of an issue. These parties can also help with the security, or certainly help flush out any issues with the security by finding out whether or not they are aware of any competing security interests. They can also help by monitoring more to make sure that you find out well in advance when issues are starting to happen. They can also help with perfection of the security, and again, we'll come on to that when we look at the storage of the goods and the role that security can play there. So in terms of storage of goods at warehouse, you have private and public. For the private ones, I think the case here is it the obligor that is the warehouse operator or a third party? If it's a third party, then you can potentially just deal with the warehouse operator in order to get protection. If the obligor is the warehouser, then you ought to be bringing in a third party in relation to any goods that are stored on their premises. You've got to do due diligence on the standards of the warehouse. Do they have insurance? What's the likely fraud risk with them? Do they have insurance? All of these things are important in making sure that nothing that happens in the warehouse is going to upset the transaction. They may also be public and they may be regulated. This would be ideal. It's the licensing, proper insurance standards, and the regulation just give a better structure to your transaction, especially if they're part of some form of warehouse receipts program, where there's legislative backing to what's going on. It gives a lot more comfort to the transaction. In terms of the issues, you've got fraud, obviously. You can't really document against that. That's really more of a due diligence point to make sure that there's lots of monitoring, lots of control and checks, and making sure that, as I say, they're doing the right things at the right time, to try and, as much as possible, avoid that. You want to make sure that they don't interfere and that you don't have a lack of control over the goods. This could be during by way of taking security. It could be by way of having the third parties hold goods to your order and have access rights for visiting the warehousing and carrying out regular checks, or having third parties do that on your behalf. In terms of who's responsible, you've got different potential parties. There's the warehouser, obviously, or the collateral manager, or a stock manager. They come with different levels of service and different levels of liability. And it's really a case of working out how risky you think this part of the transaction is, and whether the extra cost involved in getting, say, a full 24 hours a day collateral manager involved is worth it, or whether actually you're quite comfortable with the independent warehouser, and you just want someone to go in to do a balancing check on stock monitoring of the goods that are being held in the warehouse. So again, case by case basis to see how it fits in with the transaction. So the financiers, what are they really looking for? Well, obviously they want the terms under which the goods are being stored to be satisfactory, whether that's a warehouse operator or whether you have a collateral manager involved. And it may be that there's an existing agreement between the borrower and the warehouse operator that can be checked. It may need to be amended to bring it up to scratch, but it needs to cover the basics at the very least, which is the provision of the services, how they are going to help affect any security over the goods, who's actually liable. With a lot of these sorts of companies, then there's a main company, and then depending on where you are, there might be either a branch or a subsidiary carrying out the storage. You want to make sure that whichever entity it is, because they're going to be liable to you if things go wrong, that they are creditworthy, and that may require some form of parent guarantee to be in place if there's a concern there. They also obviously need to make sure that they control the goods for you, and they only release goods as and when you want them to do so as the funder. Obviously, that's critical both from a transaction generally, but also in terms of the security that you may be taking. You also need to make sure that they have the wherewithal to perform. Do they have the right level of resources? Do they make sure that the people that they're using are swapped in and out on a regular basis, so you don't get issues of potential fraud arising or collusion? You want to make sure that they've got PI cover so that they can cover off any risks that way. And as I said earlier, make sure that any liens that they may have had are waived. For the monitoring and control, they will obviously be issuing the warehouse receipts. They'll be controlling the release process for you. But you also need to make sure that you're able, or a third party is able, to monitor on a regular basis and carry out checks just to make sure that what you're being told by the warehouser is correct. So in terms of insurance, jumped ahead too much there. In terms of insurance, here it's a case of really looking at who's taking the documentary risk. Looking closely at the policy wording, the scope of that policy, the exclusions under it, the disclosure obligations that the borrower has, because it's going to be the borrower that's taking out the insurance. It's also looking at the impact of any sanctions on the insurance, and also capital relief. If you're relying on the insurance for capital relief purposes, then obviously they have to comply with the requirements under the legislation. in order for the funder to be able to take advantage of that. In terms of how you do the insurance, then it may well be that it's the borrower is insured. You might, albeit it's not that usual, want to have some form of co-insured arrangement with the lender so that the lender has more control over the claims under the policy. But that comes with it a risk, because all of the obligations that would be on the insured party normally would equally apply to the co-insured. And therefore you're effectively doubling up on the risk of somebody doing something wrong and the claim not being able to be made or being reduced in value. In any event, I would expect to see the lender as loss payee, either for the whole policy or at least for the aspects of the policy covering the goods that are being financed. And we would likely have, under the assignment of the receivables, also some form of assignment of proceeds of the insurance policy, and whether that's over the goods or over trade credit. It's you can't assign the insurance policy in the same way that you can assign the commercial contracts, because that is likely to have the effect of vitiating the policy, meaning you couldn't make any claims under it at all. Now we're going to move on to insurance, but essentially what you need to look at here is really find out what is available. You know, what fits the transaction. You have to have the correct type of security, both in terms of the asset you're trying to secure, but also the location, because the location will dictate the governing law in most cases. And especially when you come to governing laws, local laws, then they can vary quite dramatically from jurisdiction to jurisdiction. So doing that due diligence, getting local counsel involved early is very important. Also, priority we'll be looking at a little bit later. So looking at the types of security, sort of more generally, from an English law perspective, at least, you have proprietary security and possessory security as your main components. What are they? Okay, well, proprietary insurances are ones where an encumbrance is actually attached to the asset itself. So here we're really talking about some form of charge, although in some jurisdictions they call them pledges, particularly in relation to accounts. But from an English perspective, you're really looking at a charge or a mortgage, something like that. It is generally taken where there's no possession, so that the funder will not have possession. There'll be no third party holding goods to its order to create constructive possession. But they are usually registrable as a result of that, because from an English law perspective, you either have possessory securities where you don't need to register generally, or you have non-possessory proprietary securities where you do need to register. Now, with the registrable proprietary ones, you may also have competing security interests. You can have more than one security registered against the same asset. And in that sense, you need to work out what the ranking is of the assets. And if you're coming in as a second funder, it may be that you get your borrower to require its lenders, its previous lenders, to enter into some form of intercreditor arrangement. It may be that you really have somebody who had a debenture, for example, over all goods, which is quite common when you go to the emerging markets and they borrow locally, which would, in theory, cover the security assets that you want to take security over. So you have to have some form of arrangement to either release it from their security or have some intercreditor arrangement that deals with it in a satisfactory manner. And needless to say, because you're registering security, you do have to have the physical infrastructure to do so. I say that because we did do a deal a few years ago in Turkmenistan, where they had this wonderful new legislation setting out how you register security interests and had all the right protections in place for the funders. The only problem was they did not have a physical registry. So again, it's a case of looking into these sorts of practical details to make sure you're not caught out. Now, possessory security is something different. This is where the funder has possession of the relevant asset that it wants to take the security over. This can be actual or constructive, and we'll come on to that in a little while. But effectively, there needs to be a sufficient level of control demonstrated in relation to the secured asset, whether that is control physically by the funder, which is usually unlikely, or whether that is physical control at that sufficient level by a third party on behalf of the funder. You shouldn't be able to have competing security interests almost by definition, because in order to perfect security, you have to have possession of the security. And if you have possession of the security, somebody else ought not to be able to have possession of the security. So that's usually less of an issue. And there are also usually fewer perfection requirements to be complied with, other than obviously the possession requirement itself. In terms of how you achieve the constructive possession, there's a phrase, concept called attunement, which effectively is a three-stage process. The pledgeor, for example, will instruct the third party, whether that's a warehouse operator or collateral manager, to issue a warehouse receipt for goods in warehouse to the lender. That will then be issued, stage 2, and stage 3 is that third party agrees to hold the goods held by it on behalf of and to the order of the lender. They're supposed to follow the instructions of the pledgee lender, particularly in relation to the release of the goods, in order to create that level of control. But as I said earlier, if you're not going to have actual possession as the funder, and you're going to rely on that third party, then that third party will need to be able to show that it has actual possession of the goods. Now, quite often it's going to be a local law element involved in that review, but the sorts of things that will be taken into account are things like, does it have sole use of the warehouse or lease of a designated area in somebody else's warehouse? Are the goods segregated? Are they labeled? Are they the only ones with access to it? Ideally, what you want is something that's under lock and key 24/7, so that nobody other than that third party has access to them and can do anything with them. And this is really, or not just contractual. So you can have a fantastic agreement where they agree to do all of these things, but you've also got to look at the reality. In practice, do they have that level of control? Do they have that level of restricted access in order to be able to comply? Because if they don't, then the fact that you have an agreement saying that this is what they're going to do or are doing, then it won't make any difference if in practice they're not. So looking at the goods themselves, often where goods are stored, they may be fungible, they're likely to be potentially commingled, and then you have to ask yourself, well, what's the effect of that? Sometimes you can't avoid it. If you have grain in a silo or oil in a storage tank, it's not necessarily likely that you're going to be the only person with the grain or the oil in those tanks. Usually, where that's the case, the depositor of the product has the right to get back out what it put in, rather than the specific goods it put in. It will be the same amount, same quality, etc. What this means is that wherever the goods are being stored, the storer of the goods has to have the right processing and grading capabilities, so that what comes out is the same as what went in. If they're mixing different grades, then you're not going to get back what you put in, and that's not going to work. I think from there, it's a case of making sure in your due diligence that you've carried out those checks. In terms of what happens if there are insufficient product, obviously, if there is enough for everybody to go around, then everybody will get out what they put in, and the transaction carries on. If there isn't sufficient product in the tanks, then you've got to look at what's the effect of that. In many jurisdictions, they take a pro rata approach, and everybody who had rights to the product in the tank will get their pro rata portion. In other jurisdictions, it may be that people who have security over product take precedence. But it's a case of getting advice in the local jurisdiction to work out what the position is if for some reason there is insufficient product there. Obviously, on top of that, you may have rights against the storer under any agreements, or there may be PI cover or insurance to deal with it as well. But what you really want is the product back. In terms of future assets, you may have a pledge, and the idea is it's a rolling pool of assets that you want to have a pledge over the future assets as well as the current ones. It differs from jurisdiction to jurisdiction as to how to achieve this. Some jurisdictions just allow you to have a very widely described set of pledged goods in your security document, and as long as they're identifiable by the description, So again, from an English perspective, we would have a description of the goods as being those which are, in the possession or control of the funder, which have been financed by the transaction. But in other jurisdictions, it's not quite so easy. Sometimes you actually have to take a brand new pledge every time it's a new set of goods. In others, you're able to deal with it by way of an initial pledge with an updated schedule identifying the new batch of goods. So again, check the jurisdictions because it does differ quite significantly. Liens, touched on earlier, it's very unlikely that a lien is going to be part of the lender's security package, but it's relevant, obviously, in the context of third parties who may have liens. And as I mentioned earlier, you really want to make sure that those liens are either waived or that you have the ability to pay off the fees that are owed to the relevant third party and claim that back under the security package, and the monies that are paid from the goods that you have leased to you by that third party. For trust receipts, certainly from an English perspective, what you need to do is you need to have that pledge in the first place, and you need to then have the goods released subject to the trust. The idea is that where you have a trust over a pledge over the goods, and you release those for the purpose of the commercial sale that has to take place in order to get the cash in, that you release it, a trust is created over the product while it's in the hands of the borrower. And then once the borrower has sold, the trust will then bite on the proceeds of sale that are received in return for the provision of the goods to the buyer. It's sometimes the case that you've released goods and a problem arises. So we would always make sure that any trust receipt arrangement would entitle the funder to get the goods back prior to their sale and delivery to the buyer, which I have seen used twice. But it's an unlikely situation because the timing between releasing and sale is usually relatively short. You also need to look at jurisdictions to see whether or not trusts would work. Now, if you have an English law arrangement, then and that's enforceable in the local jurisdiction, then it shouldn't be an issue. But sometimes civil jurisdictions that don't recognise trusts can create difficulties when you try and use an English law trust, even though it ought to work. Particularly the case in those jurisdictions that are not familiar with these sorts of financing techniques, or they have, like in the Middle East jurisdictions, a lot of them have legislation that doesn't really work with trusts. It's just not a concept that can be recognised. So again, due diligence to make sure you don't fall foul of that one. Bills of lading. I mean, I think we probably all know how they work. I think the main point is, what are they and what rights do they give you and how do you transfer them? So as a typical transaction, you would look to take a pledge over the documents of title and the goods and any documents relating to the goods, including the bills of lading. You may also want to have that bill of lading endorsed either to the bank or more likely in blank and in the possession of the bank, so that effectively the funder is controlling the process. But obviously, from a commercial perspective, at some point, the bill of lading has to go to the buyer so that they can get the goods and make payment. Ideally, you would receive payment before they receive the document, but that's not always the case. Depends on what terms you sell. But there is a debate as to whether they are documents of title. Personally, I don't really think it makes much difference because you can endorse the bill of lading anyway. And if you don't, you have the pledge and you have the right to get the goods, get possession of the goods, which essentially means the pledge bites again and you can enforce under the pledge. So either way, you end up getting to the same place. The reason title and risk transfer is important is because you need to know who owns what goods when, basically, because you're going to be taking security from certain parties. There's no point taking security from somebody if they don't have title to the goods at the point they're taking the security. And in terms of where you look to see what the position is, well, the risk in a transaction will pass under whatever the relevant Incoterm is that's being sold under. But title to the goods is likely to be in the contract itself. So it's not just a case of looking to see, is it FOB, is it CIF, whatever. It's also a case of looking at the contract itself to see when title passes, and also what, if any, retention of title provisions are in there. they can be quite beneficial where your borrower has retention title provisions and there's a failure to pay. So again, have a look at the contract to see what rights you have or what rights you might need to try and include that are not there at the outset. Nature of warehouse receipts. I'm not going to go through this. This is really just setting out a description of what they are. For the list of what they may or may not be, the first three in particular are crucial if you have a liquid system. If you have a program, then you need to make sure that these things are covered off, because if it's not, then it just slows the whole process down. And different jurisdictions will have different rules on this, absent any particular program. So yet again, I keep saying this, the local advice is critical in understanding what rights you may have in relation to goods in any given warehouse. Some jurisdictions have specific requirements, both in terms of the format of a warehouse receipt. This will likely be set out if it's public by legislation. If it's private, then it's likely to be in some form of club rules, if it's outside of a program. And if you're a member of the club, there are contractual requirements, and that would set out if there is a format to be complied with. For negotiability, transferability, again, some places it's set out in legislation. In other places, it's just general law that applies, and again, different from jurisdiction to jurisdiction. And so lastly, in terms of potential issues with goods, the financing systems that I was talking about, some may be public. You've got, for example, one set up by for the LME, for example. Others might be a private club arrangement where everybody has to sign up to the rules there. But whichever it is, the system should ensure that the warehouse receipt itself represents the goods and therefore gives the financer the right to the proceeds of sale of those goods as and when that sale happens. There's a bit of a, in terms of the key elements that you would want the system to do, they're perhaps slightly obvious, but they allocate risk and allow the financer to enforce against the goods to recoup its money if there's been some form of default under the financing. It should also set out how the registration process goes, if there is one, and how you go about enforcing the collateral. But this is likely to be subject to local law requirements on enforcement as well. So again, check out what that is. But really what you ideally would want to have is a system that is regulated and licensed, properly insured, because what you really need is for the warehouse to perform. If the warehouser doesn't perform, then the transaction could be in trouble. And you also need to know that they are financially backed in some way, either through some centralized fund or insurance, so that if they do go wrong and they don't perform, that you're not left without any recompense to anybody. I wanted to move on to receivables now, which obviously are key to all of these transactions. They're really what makes it the self-liquidating product that it is. And there are different stages, and each stage can generate a receivable, and each of those stages could form part of the security package. But the really important point from a financier's perspective is to look at the receivable itself. What's the quality of the receivable? Does the volume, the timing of payment, does it fit with the financing arrangements? How creditworthy is the buyer? Obviously, it's potentially less important, as I mentioned earlier, if you have multiple buyers with relatively smaller percentages of the overall, or you have lesser credit in place. Ultimately, you're still taking performance risks on the seller. Is he actually going to get the goods from A to B to constitute delivery, to give rise to the payment obligation that the buyer has? If logistics issues or manpower issues, transportation issues affect the delivery of the product to the buyer, then there's no payment to be made. And whilst it is possible, it's unusual in that situation to have any sort of recourse to the seller under the terms of the contract and in terms of the goods. Obviously, you'd still have the financial liability under the financing itself. But if they do constitute delivery, and they do get the goods to the buyer and the buyer just doesn't pay, again, you've got to look at that risk. Is there some form of recourse there to the seller? Very unlikely. Again, you're looking back to your general buyer credit risk mitigation. So in terms of assignments, which from an English perspective is what you would take over the receivable, the contractual benefit is a right that can be transferred, and the assignment is the means of transferring. In terms of what it achieves, what it means is that the assignee, the lender, can get rights and can bring proceedings against the debtor to enforce the assignment, enforce the transfer, and be paid. It doesn't create anything new. You can't take better rights than the assignor has. And the obligations under the contract are not transferred. It's only the rights that are transferred under an assignment. You would need a novation if you wanted to transfer out the whole contract, but you're not going to be doing that in the context of security. So it's not so much of an issue there. The rights of the lender, the assignee, under the contract being assigned, as I said, are no better than the assignor's, but they're also subject to whatever limits, defences, or set-off rights that the debtor has, that the buyer has against the assignor under the contract. You will take the contract subject to those, unless other arrangements are put in place, which we'll come on to in a minute. Two types of assignment, legal and equitable. The requirements of the Act are that the assignment is absolute and in writing, signed by the assignor, and that there is express notice to the debtor. That notice can either be from the assignor or it can be from the lender as assignee, from an English perspective. But check local perfection requirements, because sometimes they have prescribed procedures for those sorts of notices to be served in order for them to bite in the local jurisdiction. This means the assignee can sue the debtor in its own name. Now, interesting to note that the absolute nature of the assignment does not preclude a security assignment, but it does stop you from being able to take a legal assignment of part of a debt only. So if you're buying, or if you're taking security over 80% of a receivable, you cannot have a legal assignment. You'd have to have an equitable assignment. And an equitable assignment is effectively just an assignment that doesn't meet the requirements of a legal assignment. So you might not have notified the debtor, it might not be in writing, it might relate to future rights, and you can't take that assignment yet. So we would typically have wording in our assignment documents to cover the future rights, but issuing notices at that time. Can't do that in advance. And also partial debts would trigger an equitable assignment. In reality, there's not much difference between a legal and equitable assignment. There's the possibility that you may have to join the assignor in any proceedings you take against the debtor, but even that in recent times is coming under scrutiny to see whether or not that really ought to be the case. But that's really the only main difference between the two. Although if the reason for it being equitable rather than legal is lack of notice, then you may come unstuck if there's a subsequent assignment that is notified, and you may end up having an argument over whether or not your equitable assignment takes priority or not. There are different views on that, but either way, I think it's a case of really just wanting to avoid the issue. So the difference between contractual rights and proceeds, I think I mentioned earlier, particularly in relation to things like insurance policies, you take an assignment of the proceeds, not the rights themselves. Very similar with a non-transferable LC, where you'd only take an assignment of the proceeds. You may have contractual restrictions on assignment. If you do, and then the effect of that is that if you try and take an assignment in breach of that restriction, that you wouldn't have rights against the debtor. You would just have rights as against the assignor. From an English law perspective, if the contract is silent on the point, then it means that it's not restricted, and you would get the rights against the debtor as well. You can also, even if it is restricted, try through the notice of assignment and acknowledgement to get a consent or a waiver of that right. You could also try and get some form of declaration of trust over the proceeds from the assignor, so that if the monies are paid, then not only do you have rights under the assignment against them, but the monies are held on trust pending their transfer to you. And the last one is really just saying some jurisdictions they restrict the ability to assign certain types of rights from a public policy perspective, but they don't usually apply to the sorts of receivables that we're talking about here. I guess the other points which are applicable to both forms of assignment are the priority rule, which is the first in time to notify gets the priority, assuming registration has taken place. Both you get the ability to give the good discharge of the debts and to get the proceeds and to sue. But as I said, sometimes you have to co-join the assigner in the process. Ideally, in the acknowledgement, again, whether legal or equitable assignment, you would get the debtor to give us an independent payment undertaking to make the payment on the due dates so that you could take action under that, as well as potentially under the assignment itself. And then lastly, in terms of security, bank accounts, this would be by way of the proprietary interest I described earlier, the charge from an English perspective. You don't need the possession, but it is registrable. But the question is, what sort of charge do you have? Is it fixed or is it floating? The fixed charge requires the element of control necessary to ensure that the chargeor is not able to access the funds. It also means that if somebody tried to transfer the benefit of that account to somebody else, that they would take that asset subject to your charge. So in other words, it gives you the priority that you want to secure your transaction. This contrasts with the floating charge, where you don't tend to have that element of control. The debtor, as in the borrower, can deal with the assets, and the floating charge crystallizes only on certain events happening into a fixed charge. And it's only from that point that you would potentially get some control and priority against other creditors. But again, had somebody taken security, fixed security prior to that point in time, then you would have to take your security subject to that. The control element is being able to stop the release of the monies and blocking the account potentially. We take the view that it is possible to have some sort of arrangement on a sort of case-by-case basis where excess in the accounts can be released back once payments have been made on repayment dates and interest payment dates, and that sort of limited amount of access that they have, if they comply with certain criteria, which means that the funder is not going to be troubled by the release of funds, that does not constitute a lack of control for the purpose of whether you're floating, your charge is floating or fixed. I mentioned earlier third-party banks. How do you ensure control over the accounts? Well, again, you need to have some form of arrangement with that third-party bank where they're notified of the charge. They're instructed to follow the lender's instructions in relation to the account, and they agree to do so. That gives them the ability, gives the funder the ability to control that bank account, and that's what's important. Again, you may want to have a waiver of fees, and obviously you potentially open yourself up to insolvency risk on the account bank because it's not held with the lender. The onshore issues reference is really just to say, will the bank comply in practice, even if it has been notified about these issues, if it hasn't agreed to do so. And we've had instances where banks in certain jurisdictions are too concerned about how they're going to be treated by their local regulator and how, if they're going to be sued by their customer. And so they are reticent, to say the least, in complying with instructions where they have not physically signed up to agree to do so in advance. The last point to be said on this is that in many cases where, and this is particularly for NBFIs, they're not banks themselves. So if they go to a third-party bank to control the account, they will often try to put it in their own name, and then that way they don't have to worry about taking the security, and they can just have a contractual arrangement with the borrower to release the funds without having to worry about that turning their security into floating security. The next couple of slides, I'm not going to go through them. It's really just a recap to set out perfection requirements for some of the security and some of the formalities involved, particularly where companies are signing overseas, and that has to go through frankly cumbersome, painful process of notarization, legalization, and apostilling. it's best avoided if at all possible. But I've included the slides here really for completeness more than anything else. So is security the answer? Maybe, but it should be a last resort really. There's no substitute for structuring properly. I think you've got to weigh up the taking of the security against the potential costs, particularly if you've got high stamp duty payable and the delay in trying to enforce. There are potentially alternatives to that, and it really ought to be a last resort. And the sorts of things I'm talking about are the things we looked at earlier in the structuring process. Make sure that you've got control of the goods and then the cash. You've got third parties locked in to help whenever possible, that you get the right rights under the documentation, and that the finance documentation matches the commercial documentation, doesn't upset the commercial life cycle of the deal. You need to have flexible terms to allow for things to be worked out where inevitably problems arise but can be fixed. And you need to have the rights to monitor and get advance notice, have triggers in there, security margin triggers, for example, blocks on drawdown if certain things happen. And just make sure that there's the flexibility and the variety of rights to allow the transaction to carry on even when it hits a few bumps in the road without having to take the sort of last resort option of enforcement and bringing the whole thing down. So in the last 10-15 minutes, I just wanted to run through some market developments. And the first of these is something called Project Eureka. I'm sure some of you will have heard about this, others maybe not. What Project Eureka is a project driven by ITFA, the International Trade Finance Association, to find solutions to the trade finance gap through a sort of a collaborative approach between governments, DFIs, multilaterals, commercial banks, non-MBFIs, and other interested stakeholders in the trade finance market. An advisory panel was set up with 7 original DFIs and multilaterals at the beginning of 2023, and it was sort of tasked with looking at how this collaboration could work and what's the best process to go through to try and achieve that. And where this has ended up is that later this month in Washington, there is what's called TF-COP1, which is intended to bring parties together. I think the invitees, and it's invitation only, is somewhere around 60 or 70 participants, is to bring them all together to try and work out how that collaboration can be better achieved. It'll look at all the different initiatives that different parties have in place or are looking at, whether they're public sector initiatives, private sector initiatives, programs, and it will have different sessions based on sectors, but also on geographical working groups. I think the process is intended to not just have plenary, although there will obviously be plenary sessions as well, but it's to try and brainstorm and try and come up with some sort of cohesive strategy for dealing with the gap. And part of that is the capacity building, where it's looking at trying to improve the regulatory compliance and access to correspondent lines for the local and the regional banks in the emerging markets, trying to pool resources at the larger bank multilateral DFI level in order to increase capacity that can be made available to the local banks, and generally improving knowledge and technical expertise at that local and regional bank level where they may not otherwise have had the ability to do so. And there is a pilot project. The first one is driven by the Africa Regional Committee at ITFA, and it's going to take the findings from TF-COP, take it forwards to try and see if they can make it work in practice. And then there'll be a reporting back to the advisory committees. So it was really just to sort of let everybody know what's going on there. So it's really a case of watch this space and see what happens. There are various other alternatives that are being looked at in the market at the moment. I've listed some of them here. The investment vehicle point is really just trying to use people who know how to do the SME transactions and are prepared to do the SME transactions being a conduit for lots of other investors, some large, some small, to bring it all together. And from a bank's perspective, take away a lot of the hassle factor of having to onboard and invest time and resources in KYC with the SMEs and allow them to effectively fund the investment vehicle in a way so that the investment vehicle can carry out the transactions itself and provide returns across a pool. Deep tier finance is one of the sort of new sexy words concepts that's come out. It's been looked at for a few years, and there was a BAF paper on it. But again, there are now working groups being set up to try and work out how best to implement that, which is obviously very difficult because the further you go down the supply chain to the multiple small suppliers, they won't necessarily have the technology or the expertise or the desire or even the accessibility to allow that to happen. So it's very early stages from that for working group perspective. But again, it's something which is worth keeping an eye on. Electronic documents is really just a sort of a 1 year on from ETDA, what's happened. And the answer is quite a lot. There are lots of entities out there doing this sort of thing. I'm not just talking about platforms, supply chain finance platforms at all. I'm looking at things like the ETDA, prom notes, bills of exchange. We've certainly carried out a number of transactions on that front where they're being used as part of financing of receivables, but in a way where the return is through the prom note and the bill of exchange, which is stored electronically, transferred potentially electronically to create that market. It's sort of like an old style forfeiting meets new style electronic storage and transferability. So again, quite unique still, but lots being done. And if anybody's got any interest in that, then happy to talk further on that front. Local currency funding, a bit of a struggle, but there are still some FIs that are looking into this and some payment transfer systems looking at trying to do local currency funding against benchmarks, whether that be against precious metals or some other assets where buyers and sellers in different jurisdictions can pay in their own currency and receive in their own currency. Again, still the ones I've come across still in their infancy, so to watch this space, but good potential there, I think, for allowing some, not on a grand scale perhaps at this point, but some form of local currency funding which can try and help the situation. And then lastly, shorter form acceptable templates, particularly in the SME market. They don't want an LMA style document, hundreds of pages. Something shorter, something simpler, and we're looking with certain market participants at trying to come up with some form of shorter template that can be put out into the market to try and get some form of acceptability. Again, early stages, so watch this space. And then lastly, a couple of things. There's a law commission paper that came out at the beginning of this year, which was looking at conflicts of laws and a potentially new asset class, mainly aimed at sort of cryptocurrency and tokens and the like. It had a consultation process which finished in May, so comments have come in. But the important point here, and it sort of relates back to the ETDA on the conflicts of laws, is that whereas they were looking to potentially deal with conflicts of laws as one process, whether it related to ETDA documents or not, informally, there looks as if they may be coming around to having some form of separate arrangement in relation to conflict of laws on those types of documents. And the reason that's important is because the ETDA itself did not deal with conflicts of laws. It was silent on it because they were intending to deal with it as a concept altogether subsequently. But it's important because of what's in the Bills of Exchange Act. Because the Law Commission point and the ETDA is silent as to what happens in relation to prom notes and bills of exchange, everybody is looking back at what the Bill of Exchange Act says. And there are two schools of thought as to what the Bills of Exchange Act means, because it says that where there are conflicts of laws, these are the rules that apply. Some take that to mean that, well, where there's no conflict of laws because you have an express governing law, it doesn't apply. Others say, well, no, what it means is that it precludes your ability to have an express governing law. What would have been useful is if the ETDA had dealt with that to clarify the situation, but it didn't. And that's the bit that we're hopeful that they're going to take on board and look at more closely now, separate from the general conflicts of laws issues that they were raising. And the reason this is important in the context of the ETDA to have that clarity is because if you go down the route of not clarifying and then parties taking the view that the Bills of Exchange Act precludes express governing law, then you end up in the odd situation where you have, say, an ETDA prom note with different parties in different jurisdictions, different relationships, all governed by different laws. And what happens about the ETDA? Because the ETDA is an English law statute. If a relationship under an electronic prom note is not governed by English law, then query, does the ETDA apply to it? So clarity, I think, is important, and hopefully we will get there. Late payment regulation. I'm sure some of you will have seen the news that came out earlier this week and end of last week. Just having managed to get the EU to back off on this front, is it being raised again? Well, at the moment, what's happened is something fairly early and not particularly problematic. There's a new code which companies can sign up to show that they're good payers, but it's really just a play nice, get a nice award and show off to everybody so that they want to deal with you. But what they have done, which is a bit more important, is they're now going to require in legislation in the coming weeks a requirement on larger companies to detail their payment record in their annual report. And that added to the legislation that's already in place, meaning that they have to report on the government website twice a year in terms of their payment record. It's sort of going in the wrong direction, especially when what the new government have come out and said is, yes, and we're going to be doing consultation over the coming months to bring in more provisions that are going to help SME businesses and deal with parties who habitually pay late, which may or may not cause a problem from the receivables finance market. We'll have to wait and see, but I think you should all be ready to take part in that consultation process and hopefully make sure that they don't do anything that's going to harm the market, so that they can back off on that front like the EU seem to have done. And then the last point, there is a new Hague Convention. I mean, the convention itself is not new, it's from 2019, but the UK has now signed up to it and it comes into force here in July next year. And what it effectively does is it for all intents and purposes, replicates the 2005 Hague Convention, but in relation to exclusive jurisdiction clauses, whereas the 2005 one only applied to non-exclusive jurisdiction. This is, if you like, the complementary convention, which allows it to take place where you have an exclusive jurisdiction clause. At the moment, the whole of the EU, apart from Denmark, plus Ukraine, plus Uruguay and the UK have signed up to it, but no doubt that will increase as the other Hague Convention signatories did as well. So again, something to bear in mind, so that as from next summer, it should be less of an issue as to whether you have an exclusive jurisdiction or non-exclusive jurisdiction clause. So that was really all I was going to cover. So I will look to see if there are any questions. Let me just check in the box. No open questions. If anybody has any questions, then they can either share them now, or I'm perfectly happy to be emailed to have questions asked, and I'll respond to those by email. So I'll just double check nobody's come in since then. Oh, there is a question. In relation to the ETDA, can a paper bill of exchange be e-signed? I think the answer to that question is that you're much more likely to upload a paper bill of exchange if you want the ETDA to apply to it, to upload it onto the whatever platform it is you're using, and then have it signed electronically on the platform and dealt with that way. Obviously, you can e-sign a paper bill like DocuSign, that sort of thing, but that's not really what the ETDA is getting at. On electronic trade documents, what has been the adoption so far? Well, from what I've seen, there's been quite a lot of take up. I mean, I think there are still obviously some who are waiting to see. But certainly if you speak to the main players in this at the moment, so the sort of the Mercors, the Arcits, the Lloyds, Nigios, Demicas, etc., then they're all doing transactions. Their systems are all being used on transactions. But as with anything else, it'll take time to build up in the market. But there is certainly a reasonable flow of things being done. What have been platforms that have been deemed valid under the ETDA? ETDA was silent on this. I'm not sure if that's getting at the reliable system point or something else. If it's something else, I'm not sure what. If it's the reliable system question, then, I mean, nobody has officially been deemed reliable because there's no system for deeming anybody as reliable at this point. There are various systems where advice has been obtained by them as to whether or not they're in compliance with the ETDA. I know of two in particular where they've received that advice, but other than that, I couldn't comment. And just to say, I think it was deliberately left as vague on the ETDA in that sense, because they wanted common law, which seems to be a trend at the moment. A lot of the new legislation in this market seems to be trying to leave a lot to be decided by the judges from a common law perspective, which is fine as far as it goes. But if you don't then have disputes where the judges get to make a decision, then you don't get the law being put in place. So mention registration reassignment. What exactly do you mean? I wouldn't expect an assignment to be registered. Well, it depends, Laura, where the assignor is. If you have an English assignor granting an assignment, then you would register it here. In most transactions, you don't have an English assignor. It's a local entity or an emerging market entity, and whether or not it would be registered would depend on what the local law requirements were in their jurisdiction. Sometimes they are registrable, sometimes they may not be registrable. It really depends on the local law requirements. But from an English law perspective, an assignment is registrable if it's an English assignor. Next question, if an insurer does not have a rating yet, would it be possible to offer credit insurance for other purposes than capital relief? Well, I mean, credit insurance is generally a risk mitigant, whether or not you claim capital relief for it. It's just better for the transaction. I'm not sure so much on the export finance side, but I wouldn't have thought it would be particularly different. So it really does depend on whether or not you're relying on the capital relief in order to have a viable transaction, or whether that's an added bonus. Richard, you've said yes. I hope my answer before answered your question, but if not, drop me an email. What's the alternative to taking security? It seems the process is quite time-consuming, might delay seasonal commodity trades. Well, taking security is just one potential concept. There are, as I said, I think at the end, there are other ways, making sure that the deal is structured properly, making sure that the other credit enhancements are in place if they're helpful, whether that's letters of credit, insurance, things like that. So it's it usually comes as a package with some of each. But I mean, to be perfectly honest, it's not usual to do these sorts of transactions without taking security of some form over the product and the receivables. The bank account depends on whose name the account's in, but the vast majority of transactions that we see will involve the security package I talked about, but adding in the other elements of the structuring side and the risk mitigation side to make it a better transaction. Exchange is signed by DocuSign is valid, just like wedding incoming docs outside the platform. Yes, a DocuSign is a valid signature of a paper bill of exchange, so that shouldn't be an issue. Okay, that seems to be what we've had for now. If anybody does have anything else, then please feel free to email me. Otherwise, thank you very much for listening, and have a good rest of the day. Thank you.